it looks like people are coming in, so we'll get things underway. I'm conscious of everybody's time, so thank you everybody for coming. My name is Mitchell Zadow. I'm the Managing Principal at Sharrock Pittman Legal, and thank you very much for joining us for our webinar today on protecting and defending your intellectual property. Certainly something that we see a lot of in our practice day-to-day here at Sharrock Pittman Legal. Before we get started, we would like to acknowledge the Wurundjeri people of the Kulin Nation as the traditional owners of the land on which our office is located, and we pay our respects to their elders past, present and emerging, and acknowledge their sovereignty was never ceded. And we extend this respect to all First Nations communities throughout Victoria and wherever you may be logging in from. Now, whether you've joined us for our webinars before or if it's your first time, welcome again. We hope these webinars are a helpful resource to share with you some must-know information and guidance on different topics that we think will be of interest for you. And you can catch up with the recordings and slides for our previous webinars by heading to our website and just looking for our resources page. This webinar also is being recorded and that will be put up on the website shortly. So if you do miss anything, we'll let you know when that's available. You'll find webinars there, not just on commercial law topics, but also employment law, property law, wills and estates, and so on. But today we're looking at the essentials you must know about protecting and defending your intellectual property or your IP. IP is fundamental, of course, to many businesses and organisations, and sometimes it might even be the most valuable asset of all. But sometimes we do find there are some myths and misunderstandings about how the law protects IP and the different types of IP that are out there. So, and if that isn't done correctly or at all, it can cause some serious issues and also some pretty serious financial impacts. So today we're going to cover a few things that you should be aware of, a bit of an IP 101, if you will. My colleague Samuel Ellamore and I will take you through some of the different types of IP you might come across, including copyright, designs, trademarks, and the concept of passing off. And Caroline, Callegari and Zadow from our disputes and litigation team will explain what action can be taken when your IP is being infringed by others. So that's the crew for today, and we're looking forward to sharing some of our tips and traps with you. Before we begin, I'll just run through a couple of housekeeping items. We're obviously in webinar mode on Zoom at the moment, so your cameras are not visible in the session, so don't stress. And as I said before, we are recording the session and will be available on our website soon. If you have any questions throughout the session, please do feel free to type away in the Q&A box on your screen. We'll try to cover questions as we go, but we've also put aside some time at the end for questions and answers. So we will come to your questions when we can. We are conscious of time though, and we've got a lot to get through. So if we do unfortunately run out of time to get to your question, don't worry, we will get back to you afterwards. And also share with you our contact details at the end too. So if you have any questions, do feel free to get in touch with us directly. Now, we are lawyers, of course, so before we get started, we do have some fine print. Needless to say, we can only give you some general guidance in this webinar. Everyone's circumstances are different, and that's really important to keep in mind when you're looking at your own business and your own IP. So please just consider that as we go through today's content. And of course, we can't cover everything there is to know about this stuff. We're really just doing a bit of a broad brush overview of some things to familiarise yourselves. So as with anything, before doing anything, make sure you get some specific advice and feel free to contact us with any queries about your own situation. So as I said, we've got a bit to get through today. So we'll start off. Samuel will explain a bit of information about copyright and designs. We'll go into then some copyright design overlap and things to look for with infringement of copyright and designs. We'll go over what's involved with patents and trademarks, passing off and misleading and deceptive conduct. And then we'll wrap up with some guidance and tips on enforcing your legal intellectual property rights. And there's some legal and non-legal options that we'll take you through and familiarise yourselves with that area. And then we'll finish up with some questions. So to kick us off, I'd like to introduce Samuel Ellamore, Senior Associate in our commercial team here at Sharrock Pittman Legal. Thank you very much, Samuel. Over to you.
Thanks, Mitchell. And I'll be talking us through what is copyright and what are designs as the first two types of intellectual property. And I think that slide on the screen, that image, basically captures probably the most important takeaway for today with terms of copyright is that it is basically everywhere. There's all sorts of works that that copyright will subsist in. If we go to the next slide, you can see that material which copyright can subsist in includes literary works, dramatic works, musical and artistic works, and that's a very broad category of works. It would include things like books and magazines, website articles. This presentation would be an example of material that copyright would subsist in. It includes software, plays, videos, movies, all of that can be copyright. Drawings, sculptures, even the facade of a building can be copyright in some circumstances. So it is pretty broad. And really what we're talking about when we're talking about copyright is what we would understand to attach to the rights of ownership. So things like the right to reproduce the work, to publish the work, to perform the work if it's a dramatic work. Those are the sort of rights that copyright gives the copyright owner, and also the right, to license and allow other people to do those kind of things. It's not an absolute right. There are some fairly limited, but there are some exceptions in the Copyright Act, rights for other people to use copyright material without permission for fair dealing purposes, for research or for criticism or for reporting of news. But as a general comment, if something is copyright, you couldn't use it, or somebody couldn't use your copyright material without your permission. Those are some key points about copyright. So probably our most common question that we get, people ring up and they ask, how do I register copyright? And the simple answer is that there is no process for registering copyright in Australia. And basically copyright is assumed to exist in most circumstances. So if you create an original work that is capable of being copyright, chances are it is copyright. And basically there's nothing that you need to do to establish copyright or to create copyright. If it's an original work that qualifies for copyright, it will be copyright unless you say otherwise. And it can be helpful, but it is not essential to assert copyright. So you'll see that the copyright symbol, certainly it's useful to use that to say to the world, to everybody, that you are asserting copyright in a work, but you don't need to for copyright to exist. And if you're using other people's material or thinking about using it, also be mindful of that. The mere fact that they haven't got the copyright symbol doesn't mean that it's not copyright. In terms of the timeframes of copyright, the rules are a little bit complicated. As a general comment, copyright lasts for 70 years after the work was first published, or 70 years after the author dies. It is a little bit complicated though. The rules did change in 2019, and it also does depend on the type of work that is copyright. So if you are considering using an older work, it is important to check the rules with respect to that particular work. So that's just a rule of thumb. Do check the actual rules if you're thinking of using an older work that you might think now is in the public domain. Now let's move on to designs. You can see on the screen some things that may be designs. You can tell me which ones you think may or may not be designs. Go to the next slide. What is a design? And we've got a definition there from the Designs Act. So design in relation to a product means the overall appearance of the product resulting from one or more visual features of the product. So what we're talking about here is really the design, the look, the appearance of a product. If you as a business has developed a product that has a particular look, a particular appearance that's distinctive to it, and we're talking here about the physical characteristics of a product. So we're not talking something abstract, something that you develop on a computer. It is a physical product, something that can be manufactured. and something that can be manufactured at an industrial level, if that's a product that is distinctive in its look, then that is something that you might want to consider registering a design right in. When we're talking about visual features, we're talking about its shape, its configuration, its pattern, its ornamentation. We're not talking about how it feels. We're not talking about what actually goes into the product, its materials. We're talking about its look, basically. Yeah, the next slide.
We've got a quick question, sorry to interrupt, Samuel, about would we be looking at design or copyright in relation to things like residential house plans and construction plans?
Yeah, that's a good question. And I think Caroline will get to some of the design overlap and design copyright overlap a bit later, but the actual plan itself on the paper, it's copyright, so the actual plan. But if you're going to then build the house and it's distinctive, it could be, if it's going to be mass produced, it could be a design. If it's a single, say you're doing one very specific house, it's probably in the copyright space because you don't have that industrial level of production. But do come and speak to us if you have a specific example that you want us to have a look at.
Thanks, Sam.
So unlike copyright, designs do need to be registered. And there's basically a two-step process. So designs can be registered, and then there's a second step of certification. And basically, if you do have a design that's qualifying, we would be recommending that you register them. Otherwise, you risk actually losing the protection of the law. And critical here is that a design should be registered before you make it public. So it is something, if you've got a new product, before you go to market with it, you should be thinking about registering and actually putting that process into work. There is a 12-month grace period in some circumstances if you do go public with a work that's capable of being registered, but you don't get around to it. But as a general rule, you should be thinking to do this before you go to market. And similar to copyright, a person who registers a design has the exclusive right to sell it. It also gives you protection from competitors importing products that embody the design. So that's a real benefit with registration. The second step after registration basically says that you created the design is yours. To actually enforce that right against a third party, you then have to go through a second step of having IP Australia certified. And it's a fairly streamlined process, but it is those two steps. And as I said, designs are registered and certified with IP Australia. Unlike copyright, they don't last that 70 years. A design right lasts for a maximum of 10 years. The original registration is 5 years, and then you can renew it for another 5 years. And then after that, you don't have any distinctive rights under the Design Act with respect to that design. So certainly, if you don't register, you won't have the protection. If you do register, you can get protection for up to 10 years. And I'll hand over to Caroline, who'll talk about the design copyright overlap and some enforcement.
Before you do, Samuel, just another question in a similar vein to the previous one. Does copyright apply to engineering designs as well? And can this be prior to fabrication or construction? Things around layout, arrangement, set out, configuration of equipment, etc. So
I think the answer to that is, again, and while you're in the design phase, it's in-house, and there's copyright in the actual documents that contain the information, and there'll be other, you'll have, if you're keeping it confidential, you'll have rights with respect to confidential information and trade secrets. As soon as you go to market, though, if what is important to the product is its look, its appearance, and you're producing it at an industrial level, then that's where you need to go and have the design registered.
If it's a one-off design for a particular client, you're fitting out their production line or something like that, then probably you just have the copyright in those drawings and plans.
Yeah, because you're not doing it's not producing at an industrial level.
Thank you very much, Samuel. Thanks for the questions, everybody. Caroline.
So it's over to me, and I think our questions have sort of been geared at where this overlap. There is actually an overlap between copyright and design. Kind of think of copyright as your physical 2D document where you've come up with the idea and you've drawn your kind of plans or created your ideas and put it to paper. But when you then turn that piece of paper into a 3D product, you need to think about what you're going to do with it. If that 3D product is going to be mass produced and under the Act you're going to make more than 50 items are made and sold, then that 2D piece of paper can lose its copyright protection and you're thrown into the design sphere. So that's why you need to really carefully think, like Samuel said, before you put things public and what you're going to do about it, and do you want to register it as a design? Now, there's a bit of a tricky bit here too, though, that not everything is going to qualify to be registered as a design, because it has to be something that is new and distinctive. So you can fall into that tricky space where you are mass producing a product. It is a product that is not new and distinctive. It's like every other kind of product out there on the market, and you don't have any protection in relation to that particular product, other than what we're talking about later, misleading, deceptive conduct and so forth, but you don't have a specific necessarily IP protection. There are some exemptions. I'm not going to go into it. I've had a few cases actually where design copyright cases have fallen onto whether it is a work of artistic craftsmanship. However, the test for something to be a work of artistic craftsmanship that is then mass produced and still keeps its artistic craftsmanship is quite, there's a lot of cases about it, and it's quite a difficult test to overcome. So it's one of the things you need to think about when you're starting to create products. From the moment you kind of put it onto a piece of paper as to where it's going to go, you need to think about that early in the process if you want to properly protect it. This is just an extract you can read at your own time about the overlap, and it's just a kind of pictorial of where we are at. So now we're going to nitty-gritty copyright designs. What is actually a breach? When you're talking about copyright or any type of IP breach, there's usually two types. There's the direct type, and in copyright, the key part of the test is where a substantial part of the work is reproduced in material form without your permission. We often get the question of like, what is substantial? Unfortunately, I've got to give you the lawyer's answer. There is no, tick the box, I've copied 10%, that's not substantial, because they're really looking at the work as a whole and what the important, significant, distinctive part of that work is. And if you're copying that distinctive part, it can be substantial, even if it's only a teeny little part that you're copying, if it's something that's what it's known for. Now, for that it be a breach of copyright in the direct sphere, there has to be both objective similarity between the works. So it's got to be a copy, or, as close a copy as possible. But there also needs to be a causal link between the infringer's work and yours. So you need to prove that the infringer knew of or had access to your work, because independent creation does not infringe copyright. And, you can see how that happens. Different people in different parts of the world, not knowing anything that's going on over here in Australia, could come up with the same idea as you and then put that idea out in writing. Now, usually there's going to be differences, but if you're going to be enforcing a breach of your copyright, you need to have something that links knowledge to that person that they knew of your works. It's usually easier if, it's a contractor or an employee or a competitor or somebody that you've sold your product to and then has decided not to buy it, not to keep using you and then go off there and do it themselves. So that's kind of the evidence you need and you should keep in mind. Then there's the indirect type of copyright where a third party is actually the one who's breached your copyright, but other people are importing it into Australia and using it here, knowing that you had a product here that was covered by copyright. Next slide, please, Nick. So that's copyright breach. What's a breach of design? Again, it's the key, it's without permission. It's where your design is registered, and it's where somebody offers to make a product or does make a product that is identical to or substantially similar in overall impression to the registered design. More weight is given to the similarities than it is to the differences. So again, going to the like, oh, well, what if I've got an idea and I just tweak it a little bit? We're not focusing on the tweaks when it comes to seeing whether there's been a breach of the design. We're focusing on the similarities. That's why it's always a good idea if you're, putting a new product out there to also have a look at the designs registered to see if there is a design that's already registered. Again, direct and indirect infringement. Direct if you're copying it exactly. Indirect if you're importing a similar product. Often happens where people are importing stuff overseas from China that have copied like a well-known designer. Frequent breaches occur in the area of furniture and lighting, and I've had a few cases in both areas. It's a bit of a tricky area because to be a designer has to be new and distinctive. How distinctive, for example, can a chair be? So if you're in this space and either you want to protect your design and you think somebody's breaching it, or somebody said that you've breached their design, it really is important to kind of get legal advice at that point in time, because there are a number of ways to either attack it or to defend an argument in relation to a breach.
Questions come through, Caroline. You were talking before about possible sort of that causal link with copyright claims and possibly a defence on the basis that you came up with the idea independently. Is there a similar concept with designs and producing a design independently?
No, because there is the register there that can be searched, which is why I noted that if you're going to do something that's not breaching a design and you want to put it out there and you want to protect it, you should be checking the design register. But again, not everything that is in a 3D product is a design that can be protected under the design register, because it has to be something that is new, novel, and distinctive when you compare it to the prior art base, which is why I've given the example of furniture and lighting, because there's only so many ways you can design a light, and in order to get protection, there has to be something new in that, the design and the shape of that light fixture, for example, that nobody else has ever done, in order for that of yours to be protected.
But the reason there's that protection with copyright infringements, of course, is because there is no register of copyrights.
Yeah.
So you can't possibly search it.
Exactly. And you can't, like, how are you going to search Google as to whether somebody's had something that's similar to you? And they don't expect it, because there's so many different forms of copyright. Whereas design, it only protects certain products who meet the test of novel and distinctive, and there's a register that you can check.
One final question before we move on to the next topic. A bit of a hypothetical, so you may or may not be able to handle this on the spot, Caroline, but say you read a book 30 years ago and you know it exists and what it's about, and what if you write a book today in a similar style without referencing that book? How important is the mere knowledge of the existence of the book compared to, is there a temporal sort of connection to it, or just the knowledge of that book existing, even if it was 30 years ago? Could that be an issue?
Well, the temporal doesn't matter. There's no copyright in ideas. So the idea of the book, because we all know, for example, romantic comedies, they all follow the same, like, similar idea. Boy meets girl. They love each other at first sight, or they're the enemies to lovers. There's those kind of tropes. So taking that kind of idea from a book is not necessarily breaching copyright. But if you are taking a substantial part of it, so your scenes mirror their scenes, you've taken big chunks of slabs and the whole thing copies it, then you start to get a lot closer to breaching. And I can't remember the name of the case, but I think there was something to do with like Jaws and a shark case where somebody tried to make a movie that was very similar. Now, if you're following the exact same idea as Jaws scene by scene, well, you're going to be in breach. If you're just taking the idea of a killer shark and you put your own spin on it, probably not. But again, the typical lawyer's answer, it depends.
Good answer. Thanks, Caroline. Did you have anything else to add?
No, I'm all good for mine.
Great. Thanks for the questions, everybody. Thank you, Caroline. I'll just take us through now some other types of intellectual property briefly, which you may or may not be familiar with. Firstly, I'll touch on patents. I'm not going to spend a lot of time on this because it's quite a technical area. And when it comes to applying for a patent registration, it would usually involve a specialist patent attorney because they can assist with the drawing up of the technical specifications and so on. But it is good to have a working knowledge of what a patent actually is. So the purpose of a patent is to protect IP that is associated with an invention. So you can use a patent to protect devices, substances, methods, processes, things like that. It doesn't necessarily have to be a machine or an object, but there are some requirements that you need to satisfy in order to get a patent. And similar to what we were talking about with designs, there's got to be a novelty about it, something new and distinctive from what's already there in the market. It's also got to be useful. So something that can be made or used in an industry. So it's got to have a practical aspect to it. And lastly, it's also got to be inventive. So it's got to be different enough to what already exists out there in the market. So it can be quite a high bar to get over, but when certainly it's there, it's available when you do have something that possibly meets those criteria, something new, something useful, something inventive, something that can be applied commercially and industrially. The novelty issue is the one that is a really critical one and easy to trip up. It's really important, similar with what we talk about with designs, that you look at registering and applying for your patent before it goes public and before it goes to market. We often hear of people who will come up with something and they're showing it at trade shows and they're shopping it around to potential manufacturers or places they might license it to commercialize it. That's really going to be very problematic when it comes to going and trying to patent it because the cat's out of the bag. Everyone you've shown it to knows about it. They know there's no longer any kind of secrecy around it. There's nothing showing it's just your knowledge about that product and that invention now. So do be very careful, be very cautious. If you do have an invention and you are showing it to potential manufacturers or suppliers or customers, do that very carefully with advice. And there are usually things we would recommend to put in place when it comes to confidentiality and things like that, of course. So patents, just a bit of a working knowledge there. But if you do have any queries on that, please do get in touch. There's something we want to spend a bit more time on today is trademarks. That's something that we deal with very frequently, both in terms of applying to register trademarks, but also taking action where there's been an infringement of trademarks that are held by our customers. So I thought it'd be useful to just really get down to brass tacks about what actually is a trademark. So a trademark is a sign that's used to distinguish your goods and services from others. So you can think of it really as a bit of a badge of origin. That's where the concept of a trademark originated a couple of centuries ago. It's literally a mark or a symbol on the product to say this is where it's come from. And the idea of that, of course, is that customers can know and trust the origin of the goods and the source of the goods. So the Trademarks Act, which regulates this area, defines a trademark as a sign used or intended to be used to distinguish goods or services dealt with or provided in the course of trade by a person from goods or services so dealt with or provided by any other person. So a couple of key kind of elements in that. First of all, it's in trade. So we are talking about the commercial kind of use of the symbol or the mark or the sign. And that concept of a sign is something I'll explore in a moment, because there are a number of different things that can be trademarked. I'll come to that shortly. The final point on that slide is that it can be registered or not. So unlike copyright, there is a system of registration of trademarks in Australia and internationally. Generally, it would be highly recommended to register your trademarks if you qualify and meet the criteria. But even if you do not register a trademark, the fact that you use a particular brand name or a particular logo or something like that is still, in essence, a trademark. It's a symbol of origin of your goods or services. It just doesn't happen to be registered. So you're not going to have the same level of protection and options in the case of infringement that you would if it was registered. But it's still a trademark for all intents and purposes. There will be some other options you can look at, which we'll come to shortly. So as I was saying before, a trademark can come in many forms, and most people would be familiar with logos and words, so brand names, product names, things like that. But a trademark can be in many other forms as well. So you can have phrases, for example. So some of you may have seen our phrase here, slogan at Sharrock Pittman League is "on your side," which we have trademarked. And colours can be trademarked. Cadbury purple is a very well-known and famous one. Shapes, so the Coca-Cola contour bottle design is perhaps one of the most well-known shape trademarks. You can also trademark movement. So trademark by Toyota for their classic jump in the air, I got a feeling movement. There was a bit of stoush a few years ago between Toyota and Jetstar, who tried to register something similar. And scents is a bit of an unusual one, very unusual. Only 2 registered scents in Australia that I'm aware of, including eucalyptus scented golf tees. So there you go. So very difficult to get a scent one. There's a few hurdles you'd have to jump through to have the right sort of connection between the scent and your company or brand, but it's possible. So just think broadly about the things in your business or organisation that potentially could be registered as trademarks. Things that really, when it boils down to it, are identifiable to you and to your business. There are some key requirements for a sign to be eligible to be registered as a trademark. So first of all, the mark needs to be inherently adapted to distinguish the designated goods from the goods or services of other persons. So what that means in practical terms is that the mark needs to be something original and distinctive, so it's different from others. What it is not is a generic word. So it's very unlikely you'll get approval from IP Australia to register a trademark if it's based on a word or including a word that other businesses in that same sector should need to be able to use in their own businesses as well. So, for example, if you're a fruit grower and you try to register apple as your trademark or part of your trademark, that's probably not going to happen, because other IP Australia will say that other fruit growers need to be able to use the word apple. You can't have exclusive rights to that. However, if you're not in the fruit growing game, but you make computers, then maybe Apple is capable of being distinguishable and linked just to your business, and you may be able to register that. So along those sort of lines, it's really good if you've got made up or invented words, because they're less likely to be generic or commonplace words that competitors might be able to use. There is another option if you're using words that might typically be knocked back by IP Australia for the reasons I've just mentioned. You may be able to still get it up if we can provide evidence that it was distinctive at the time of filing the application. So, for example, if you've been using that word or that mark for a little while and you've started to build up some goodwill around it, some brand recognition, We've had cases in the past where we've provided evidence to IP Australia to show that over a number of years, this is how we've been using it. This is the extent of our use. This is our position in the market, etc. And then IP Australia may be satisfied that even though if you were going to go with a fresh application today, it might not be successful. The fact that you've been using it over time and built up that brand recognition and link to your business is capable of registration because it's distinguishable now to your business. So what happens in terms of registering a trademark? Well, it involves a few steps. It's not a very complicated process, but it is a long one. So it is good to get started sooner than later. So first of all, we need to look at what are we actually applying for? What are we wanting to register as a trademark? What are the elements? So a common approach that we would take is to, if you've got a brand name, for example, is to consider registering 2 applications, in fact, one for the word and one for the logo design itself. So that way you're going to stop competitors from using your logo on their products, but also they've prevented from even just using the word in text, copy text on their website or something like that. Next, you consider the classes of goods and services that you want to apply for. So unfortunately, it's not possible to have a single trademark application or registration that covers every type of product under the sun. There's a number of different classes of goods and services, and you need to identify which class or category of goods and services you are planning to operate in, and then apply for your registration to cover that particular class. It's really important to make sure that that is done carefully so that you're making sure you do have that trademark protection in all the different sort of categories of goods and services that you're operating in and trading in. And there is a fee that IP Australia will charge per class. So if we're looking at a strategy of a word application and a logo application, and we identified 3 classes, well, there's going to be 6 lots of fees to IP Australia, usually around $250 per application per class. And then it's a matter of filing with IP Australia. We would typically prepare that and file it, and but you do have to be prepared. It's going to take about 7 or 8 months to work its way through all the different stages with IP Australia. They'll examine it, check that it meets the criteria. If not, they'll come back and ask some questions. Maybe they want some more evidence of prior use, things like that, or maybe narrowing down the classes of goods. And then they'll go through the process of advertising it publicly. And if there's no public objections that stand up, they will register it. But the good news is your protection will be backdated to the date that you file the application. So that, again, the sooner you get that in and get the ball rolling, the better. And it also means the sooner your application is in, you'll probably should have priority over someone else who comes along and tries to register something similar. So that is a little bit of a recap of, in a nutshell, on trademarks. I'll just note in passing a comment or a question we've had in terms of why would anyone want a smelling golf tee? That's a good question. I'm not quite sure where they sell them. With the eucalyptus scent, it could be an overseas market. I'm not quite sure, but very good question. I've wondered that myself. Now, passing off is something that's a bit more conceptual, and it doesn't sort of fit in with the classic sort of copyright, patents, trademarks, trifecta that you would see IP Australia dealing with. But it's an alternative way of taking action to defend your brand or your mark, your identifier, from misuse by others. So, for example, if you have a brand name, maybe you weren't able to register it as a trademark, it didn't tick all the boxes, but you're using it as your brand just in the course of your business. This might be something that you can look at if you're feeling that a competitor has come along and trying to ride on your coattails a bit. So passing off is something we find in the common law, which means that the principle and the laws around it come from case law rather than particular legislation or statute. So passing off usually occurs when one party misrepresents their goods and services as the goods and services of somebody else. So there's a few key criteria that would need to be satisfied and tests that need to be satisfied if you're going to make a successful claim for passing off. First of all, you need to have a sufficient reputation yourself in your goods and services and your brand in the market. So you must have been able to demonstrate that you've built up a positive image or brand through your goods and services over time. If you haven't got a reputation out there in the market, it's going to be hard to show that someone's trying to trade off of that reputation for themselves and for their own gain. The second element is you've got to be able to show misrepresentation. So what has the other person done that we think is passing off and writing off your reputation? Are they making false and misleading representations to the public that their goods come from your business and your brand? Are they making other sort of representations? Sometimes this, if it does go to court, which fortunately doesn't happen often, but sometimes it does, of course. Sometimes it actually involves commissioning some market research to go out there and say, well, what can we show the typical consumer out there would be confused by if they were, would they be able to tell where these goods were coming from? And finally, damages. So it's one thing to be able to show that someone has potentially breached your or passed off their goods or services as coming from yours and trading off your reputation. But you've got to be able to show there was some damage or loss caused by that. So that could be lost sales, damage to your reputation, particularly if they were poor quality goods being sold by that person, or other sort of forms of harm as well. So if we can satisfy those three criteria, then we can go and seek remedies from the court. That could involve things like an injunction to stop the other person from doing what they're doing. Could be some damages. It could be an account of profits to compensate for the profits that they've earned that they shouldn't have, and those sorts of things. And then just finishing off here, the final sort of area of IP we wanted to cover was misleading and deceptive conduct. There are some similarities between misleading and deceptive conduct and passing off, but whereas passing off is more of a common law action, misleading and deceptive conduct is something that's prohibited under law, specifically the Australian consumer law. So section 18 there of the Australian consumer law says that a person must not in trade or commerce engage in conduct that is misleading or deceptive or likely to mislead or deceive. So that's, we could do a whole webinar on misleading and deceptive conduct and the Australian consumer law, of course, but in the context of IP, that can arise in various ways. So a business might make representations about the origin or quality or characteristics of their goods or services, which are found to be false or misleading. They might claim that they own the particular IP or the patent or the copyright in a particular product when they don't. Those sorts of things. And the ACL does provide certain remedies to protect consumers. That's another sort of difference between this and passing off, as this is more a consumer protection type of area and rationale. And there can be damages, compensation, action taken by the ACCC as well, and they can seek penalties. So the court has quite wide powers when it comes to dealing with a misleading and deceptive conduct claim. And sometimes we see in practice that it might not be possible to actually succeed with a passing off action because of those three elements we talked about. That can be quite a high bar, particularly showing the reputation and the confusion that it would have out in the market. So sometimes we do see misleading and deceptive conduct cases being run instead, because it's slightly easier to satisfy those criteria sometimes. And an interesting one that we've seen in the media just in the last few days, of course, was the war between Moccona and Victoria Coffee, where Moccona is taking on Victoria and saying that Victoria are engaging in misleading and deceptive conduct by selling their coffee in jars, and Moccona say that they have developed a distinctive look and recognition around their glass jars that they've used for many decades. Interesting that they're not alleging that Victoria are passing off their coffee and as Moccona, and probably for various reasons there, they could say that the label is different enough and so on. So it'll be interesting to see where that one goes. I personally think there's probably enough difference between those two glass jars, but you can make your own assessment there. So I'll hand over now to Vash, who'll take us through a bit more detail about what to do when we're talking about infringements of these types of IP. We do have a question first, though. How do these cases even go to court when there are obvious differences? It's only certain consumers that would ever think they're the same. Well, you'd be surprised, particularly the ones that go to court tend to be these big companies that have invested a lot of money over time developing their brand. I read that Moccona, for example, have spent a lot of time and money over the years marketing that glass jar and the shape of that, even in using it in advertising without the word Moccona on it, to try to generate brand recognition just around the shape of their jar. So when you've got big companies like that spending a lot of money, they will spend a lot of money to try to protect it. And sometimes it's justified, and competitors will come along and try to push the envelope a little bit. And this is one such case. But usually when it goes to court, you'd find that there has been some other goings on behind the scenes over some time. They've probably tried to deal with it privately and then gotten to the point where they feel they've got no alternative but to go to court. And sometimes that's also a strategic thing, going to court, where obviously everything is in the public domain. Something like this is going to get some media attention happening. That there could be a strategy that going public with it is designed to put a bit of pressure on Victoria to back down. So there's always some twists and turns.
Yeah, I was going to add in there too, from the strategic point of view, sometimes it's also about you can't get the other side to listen. And in the federal court, one of the things that they do, and they do very well in the federal court, is mediations. So sometimes it's about getting the other party to the table to mediate kind of an outcome which might prevent the misleading and deceptive conduct from occurring, or to help distinguish the products a little bit more, to keep your brand recognition out there, especially if it means something important to you and you've spent, you as a company have spent a lot of money on marketing and having your marketing based on that particular product. It might be about forcing them into having a commercial discussion before a registrar who's going to mediate it with you, knowing that there are risks in all litigation.
Good point. Thanks, Caroline. Vash, over to you. Thank you.
Awesome. Thanks for that, Mitchell. So might just go to the next slide there. So what constitutes a breach of a trademark? So on the slide is a few things just for you to consider. But basically in Australia, the Case Law and the Trademarks Act of 1995, particularly Part 12, govern how trademarks are breached and how the courts interpret acts which constitute a breach of a trademark. So the most common ways that your trademark can be breached appear in circumstances where you register a trademark and another person or another entity uses a sign that is substantially identical or deceptively similar to your trademark in relation to goods or services for which you have actually registered your trademark. Now, whilst these acts can lead to a breach of your IP rights, it's always important to remember that you need to ensure that the person who's the breaching party hasn't actually established any defences, or that there aren't any exceptions which apply to the alleged infringing act as well. So a key point to note here is that a person is not taken to have infringed your trademark if that person can establish that using the sign in the way that they did is not likely to deceive or to cause confusion as well. Next slide. Thanks, Mitchell. So what is substantially identical? The case of Shellco Australia Limited and Esso Standard Oil Limited outlined a test in which the courts used to determine whether a mark is substantially identical. The courts determined that in considering whether a mark is substantially identical, they should be compared side by side, noting their similarities and their differences, with the importance of these essential features being assessed and having regard to the total impression of resemblance or dissimilarity that emerges from the comparison. So the court will consider the burden of evidence, the arguments made by each of the parties, and then come to a conclusion on whether this element has been met. Now, if the court does determine that the marks are not substantially identical, the next step is then for a court to determine whether or not the trademark is deceptively similar. So just having a look at what is deceptively similar. Again, it was another test that was outlined in the case that's on your screen over here. Basically, the test ascertains whether trademarks meets the criteria of whether they are deceptively similar. And in simple terms, the test provides that a court must estimate the effect the registered trademark will have on the mind of a consumer across all goods and services for which you have registered your trademark. And then based on the impression retained by the consumer, the court will then consider the basis of any mistaken belief that trademarks are the same. And basically, in other words, will a consumer be confused? So Section 10 of the Trademarks Act also defines deceptively similar, which for you to view as well. So I guess ultimately the test for deceptively similar considers the state of mind of an assessor and whether there is a real or tangible danger of deception and confusion occurring, whereas a mere possibility is not sufficient to pass this actual test. So next slide, thanks, Mitchell. Now, when is a trademark not infringed? So now in this case here, that's been out in the news recently. This is Katy Perry versus the singer versus Katy Perry, the Australian designer. Basically, this is a recent federal court case in which, in relation to trademarks, and at a very high level, the Australian Katie Jane Taylor sold clothes under her maiden name, Katy Perry, since November 2006. And had a trademark registered in September 2008. Now, she alleged that the singer infringed her trademark from at least 2013 by selling products with a mark substantially identical to or deceptively similar to her own, and also claimed that she began her business well before she was aware of the singer, which meant she was the rightful owner of the trademark. Now, the federal court has recently found in favour of the Australian Katy Perry, and whilst the court noted that the singer used the name in good faith, however, the singer's company, Katy Perry, had been ordered to pay damages for breach of a trademark. So just considering when a trademark is not infringed, given the high-level scope of this webinar, I won't go into each exception. However, at a high level, scenarios may include where a person uses a sign in good faith to include the kind, quality, quantity, intended purpose or value of goods or services, or a person uses your trademark for the purposes of comparative advertising. So Australian statute and case law deals with each of the above scenarios and other instances in which a trademark is deemed to not have been breached. Therefore, if you believe your trademark has actually been breached, it is good to reach out to us and let us know so we can provide you with more detailed advice on whether your trademark has actually been in breach, or if there are any defenses or any exceptions that have been applied to the use of that trademark. And if your trademark has actually been breached, then what remedies are available to you as the owner of those exclusive rights. Next slide, thanks, Mitchell. Now, as Mitchell mentioned, passing off is a law that is enacted under the common law. So when we look at claims in the area of litigation, we consider the test that's outlined in the British case that's on your screen there. Now, the test has been widely applied in Australian court rulings today, and the existence of a reputation in the market is a key element in the tort of passing off. So at a high level, again, where you believe the actions of the other person or companies are passing off their products as your own, or representing that their products have an association with your products, then this may constitute a breach of the tort of passing off. In most circumstances, if you're seeking to establish a claim for breach of trademark, normally your lawyers will most likely seek to establish an alternative claim for breach of passing off under the common law if the claim for breach of your trademark is unsuccessful on either a technical or other ground. Next slide, thanks, Mitchell. And then in the event that a person or company has breached your trademark or is found liable for breach of the common law tort of passing off, then a person may have also breached laws relating to misleading and deceptive conduct, which Mitchell touched on earlier in the webinar. Again, on the screen for you are a few sections of the Australian consumer law, which relate to actions businesses must avoid to ensure they are not found liable for misleading and deceptive conduct. Ideally, the two fundamental rules of advertising and selling. The first is do not engage in conduct that is likely to mislead or deceive. And the second is do not make false or misleading claims or statements. You will note the provision used in the provision of the ACL and consumer law uses the term person. However, as part of the Australian consumer law, the term person is also defined to include a corporation or an individual as well. Next slide, thanks, Mitchell. And so on this slide here, we just note that if you are a director of a company and your company has actually engaged in misleading or deceptive conduct, or if another company has a director that's engaged in misleading and deceptive conduct, then in certain circumstances, the director of the company could actually be held personally liable as well. So depending on the severity of the breach, not only can there be civil action taken by the ACCC, but also pecuniary penalties imposed as well. So where misleading and deceptive conduct has occurred, there is a vast array of remedies that are available to you if you have likely to have suffered loss or damage. And these remedies can include damages and again, account of profits, or if you are trying to stop someone from doing something, then injunctions are available as well. So again, if you feel someone has made any misrepresentations towards you or has induced you into entering into a contract or transaction based on the use of any trademarks, then reach out to us and let us know, and we'll see if we can assist.
Thank you very much, Bash. And on that note, I'll hand over to Caroline in a moment to take us through some more, just to finish off, some more practical things to keep in mind if you do think there is an infringement that's taking place. I'm aware of the time, so we may need to run another sort of 5 or 10 minutes over time, if that's all right with everybody. If you do need to get going, please feel free, of course, and you can catch up on the recording later. So thank you, Caroline.
So, enforcing your intellectual property rights. I'm hoping this was the part that you were all waiting for so that people don't drop off, but I am conscious, and so I might go through this a little bit faster than I ordinarily would. Key question: when does infringement occur? Well, infringement occurs when a person or an entity acts without the consent or the authority of the IP owner and does one of the acts under each of the legislation that is exclusively reserved to the IP owner. Liability for breaches are usually strict, particularly if you can satisfy the elements, but there are some exceptions and some defences. I'm not really going to go into detail on that. So in terms of legal options, what can you do if you think your IP has been breached? Well, the first step, as always, is send a letter of demand seeking that they cease and desist breaching your IP rights, but you need to make sure that your letter is justified and you have evidence backing up your claim. If you're for registered rights like design, trademarks, it's a lot easier. As we mentioned earlier in the copyright, it's a little bit harder because you need to prove that they had knowledge of your product. But the first step is actually send a letter of demand. If that doesn't work, well, you can commence legal proceedings to protect your IP rights, usually in the federal court. As others have said, you can claim permanent injunction to stop the continued breach of your IP. And you might also, when you get in early, be able to get a temporary injunction ordered urgently if the breach is clear and serious and you're willing to give an undertaking as to damages, which is you saying, well, if I lose, I'm going to cover the damages of the other side in short terms. What you can also get is either damages or an account of profits. That's to compensate you for monetary loss. They differ in what you can obtain, and it depends on the circumstances as to whether you would claim damages or an account of profits. It depends on the breach and what actual loss that you have suffered. Generally, if you can prove that using your IP has actually caused you to, lose customers, lose contracts, etc., you'd go for damages. If it's harder to prove that loss, then you might go for an account of profits, which is where you get the other side to basically disgorge to you the profits they made from using your IP. So I think we can probably skip the next slide, Mitch, because that was just a summary of damages and loss of profits. There are some other non-legal options without going to court, because we know people don't like going to court. There's never a guarantee in litigation when you go to court as to what will ultimately be found, because it is a matter of a judge interpreting the legal tests. So there are other ways to stop it, depending on where it's occurring. If the breach is occurring on a website or through Google, you might be able to get the web page removed from the Google searches, or the web page pulled down, or the particular app, if there's been a breach on there, to remove that user from the app. But whether that's going to work is going to depend on the terms and conditions of the particular site. I've provided a link to Google. It doesn't just apply to copyright. They do have takedown notices for trademarks as well, but they have a very clear process there. Takes some time. You've got to write, fill in a form, write a letter, and prove your ownership for that to happen. But look, if you can't get the other side to stop, it can actually be a good way of getting the breach to stop, and quite a quick way considering how long it takes for you to get a judgment in a court.
And we often find, don't we, Caroline, that that's the main thing that people are after, is just to make the other person stop. Because it can be hard to show profits and damages and so on. So sometimes just getting them to take it down is the most critical thing.
Exactly. And if you can't get them to do it, there are sometimes you can get a third party to do it for you. Other non-legal options include if you are both small businesses seeking a mediation through the Small Business Commission. And that's often where you can then either try and find a deal, or get them to agree to take it down, or get them to agree to do certain things that might help protect your reputation. And that's quite a cost-effective method of mediation through the Small Business Commission if you qualify. You may also negotiate with the other party. So rather than getting them to take it down, maybe you'll negotiate a commercial deal for you where you actually license your IP to them for a fee, and make some money out of it. Make some lemonade out of the lemons that's occurred. That doesn't often happen, but it's always an option. The reason we tell you to come to us where you think there's been a breach of your IP is not because we're the lawyers out there trying to make money out of you, but because there are actually risks when you're trying to protect your IP. If you are actually making an unjustified threat of a breach of your IP, then you could be the one that is ultimately having to pay damages to the other side. So you've got to be really careful. You've got to make sure that you've got a reason for making that threat, because in each of the different acts that protects IP, the Copyright Act, the Designs Act, the Trademarks Act, and the Patents Act, there are penalties for unjustified or groundless threats of breach of IP. It doesn't need to be a threat made in bad faith to be unjustified, but it needs to be a threat that's made without a good legal basis. And because the area of IP law is quite tricky, we do recommend that you get legal advice before you send your cease and desist letters. It's also important, no matter what type of IP you're protecting, and if you think somebody's breached it, get legal advice as soon as possible, because the sooner you take action, the less loss you're also likely to suffer. So I'll leave the last bit with some general tips to protect your IP. This is the stuff that you can do before anything else happens. Do searches to make sure your IP is original and not a breach of somebody else's IP to protect yourself from a claim against you. This is not necessary, as Samuel said, but you might, if you're putting it out there in the public domain, want to take steps to identify your IP, use the copyright, trademark sign, etc. If you've taken, you've got specific pictures and your business, those pictures are important to your business, you might put some watermarks on them. So if somebody copies it, that you can see that it's yours. Register your IP where it can be registered and do that early to give you protection early. Have clear contractual terms about who owns the IP and what can and can be done with your IP if you are sharing it with a third party or creating it with a third party, or having a third party manufacture your product. So you might design the product and the other third party to manufacture. You want to make sure you've got some clear things in those contracts about who owns the IP and what that third party can or cannot do with it, and ensure you have confidentiality regimes in place. Employee contracts should cover IP rights too, particularly if they're high up and they're going to be involved in producing IP for you. Consider the use of non-disclosure agreements where you're sharing IP. Monitor for breaches. Regular random Google searches or searches of the trademark register can be quite helpful, and take steps early to enforce your rights where there are clear breaches. Hopefully that's kind of covered it in a nutshell for you and is helpful in moving forward in your businesses.
Thank you very much, Caroline and Vash and Samuel too. We won't have any more time for questions, everybody, but I will put up our contact details shortly. So do feel free to get in touch if you have any questions on anything we've covered. It's been quite a lot of ground we've gone through, so do get in touch. We also have some articles on our website, which we are constantly updating and adding to, some on the area of IP in particular. So do explore there if you'd like to. Follow us on LinkedIn and other social channels, and you'll see when we post new content, so you can keep track of things and keep up to date. Just before we wrap up, a couple of things, if you don't mind. We've got another webinar coming up next month on employment law. That will be with Samuel, who's our workplace relations accredited specialist. So we'll share some more details of that soon. And also just a reminder about David Sharrock's book, Fighting for Enterprise Success Through the Eye of the Tiger, available in hard copy and ebook. So that's got lots of samples and templates from our own business, but lots of guidance and practical things from David in terms of taking a systems approach to your business or enterprise and how that can drive enterprise success. So that brings us to the end. Thank you very much for joining us. Hope it's been of interest and we've been able to sort of scratch where you're itching a little bit in this area. And as I said, if you do have any questions, please feel free to get in touch anytime. We're always happy to have a chat. So in the meantime, we'll leave things there. Thank you very much and have a nice day.